The 11th season of Consider This is brought to you in part by From the Top, a national program showcasing the musical talents of young people. From the Top can be heard on KVNO Classical 90.7 each Saturday at 6 p.m. Consider This, a program of issues and information behind today's news. Once again, from the campus of the University of Nebraska at Omaha, here is your host, Kathy Wyatt.
About 50% of all marriages end in divorce, impacting couples emotionally, socially, spiritually, and financially. And then there are the children. Hi everyone, I'm Kathy Wyatt. Welcome to this week's edition of Consider This. Our topic, divorce and kids. Here to talk about it today are Chris Johnson, an attorney from Hastings, his client Eric Cato, and then Susan Ann Koenig, who is an attorney in Omaha, and her client, Lori Trim. Thank you all very much for joining us and welcome.
Good afternoon.
Thank you.
Glad to be here.
Chris, we're going to start with you. Could you just define divorce for us?
Well, divorce is a legal end to a legal relationship. In the eyes of the law, people come together, they become married, and when they become married, they form a civil partnership. If later they decide that they no longer wish to be married, then there has to be a dissolution of that civil partnership, and that's what dissolution, as it's called in Nebraska, or divorce would be. In a divorce, everything that the marriage accumulated has to be divided. You have children when you have marriages most times, and those children need to be cared for after the parties are no longer going to be living together as man and wife. So decisions need to be made either by the court or by the parties as to what's going to happen with the children and how they're going to be raised from that point forward.
Okay, thank you. And Susan, just how many kids in Nebraska were actually affected in 2007 by divorce?
You know, in recent years, Kathy, about 6,000 Nebraska children are impacted every year by divorce. That's not counting other custody litigation arising from modifications or paternity cases, but in divorce alone, about 6,000 every year.
Okay, a lot of kids. And Eric, I know you're in this boat. You have 3 children. Can you talk to us a little bit about your circumstance?
Well, we were married for 16 years, 3 kids, and just mainly a traditional family as far as that goes. And the ex-wife, was a stay-at-home mother, and I was a business professional. And that's, I guess that's how the jobs went as far as that goes. So.
And what is, I think you mentioned that your divorce is going to be final in August. What is the outcome? What was the decision concerning the kids in your case?
Well, it's still ongoing as far as that. We've tried to keep the kids in mind here as far as what we've tried to go as far as a 50-50 custody, tried just to see if we can get along with that. Right now nothing has come to light, so I think it's probably going to end up in the trial phase here. So.
Okay. And Lori, what about you? You have 1 child, I understand.
Yes, one
Talk to us a
son.
little bit about your circumstance.
In my situation, we did not agree on a custody arrangement going into the trial, and attempts at mediation were unsuccessful. And so in the interim, the court awarded a visitation on a 3-day, 4-day, 4-day, 3-day alternating situation. And frankly, that was very cumbersome and really hard to manage that kind of situation. Changing in the middle of the week, it was hard on our son. And ultimately, we got 50-50 custody, 1 week with me, 1 week with his father, alternating on Sundays. And that's working out a bit better.
Okay. Chris, are these pretty typical responses that we're hearing?
They are and they're not. There are parenting plans, which Nebraska is now requiring, that are put together by the parents, which can be a 50-50 division of time. That's what Eric is seeking. That's what Ms. Trim has received. And then you have the more traditional realm of thought that moms get custody and guys don't, and you have visitation plans as opposed to parenting plans, which might limit a non-custodial parent to having 2 days every 14, maybe some time in the summer as well, and some holidays. And other than that, it's not their time, so they don't have access to their children.
Okay, and you're saying or suggesting that that's more typical than the responses that we've received?
I think that is more typical, but it's moving in the other direction.
Okay, and Susan, I'll let you comment on that too. What is your response to what I just asked?
Well, what I really appreciate about what Chris just said is that we really are seeing, in my experience, a transition of how courts are viewing parenting arrangements after a divorce. And I've been practicing law for 27 years, so I've watched this for a long time. And what we're seeing today, I think, are more cases of closer to equal time sharing, not necessarily a lot of 50-50 divisions, but less of if we might call it the traditional arrangement. So, and I think that that's arisen out of Nebraska saying we are going to have parenting plans in every case.
Okay, and talk to us a little bit more about the details involved in this parenting plan. Picture that for us.
A parenting plan is a document which sets forth two aspects of how the children will be cared for after a divorce. One aspect is how the time will be shared between the parents, such as week to week, as Lori was describing, what is the schedule, what happens for holidays, birthdays, summertime. So the sharing of the time, what we commonly refer to as physical custody. The other aspect of a parenting plan is how decisions are made, what we call legal custody, who decides what school, what doctor, and so forth. So this document has a lot of detail, everything from extracurricular activities to emailing, giving notice to the other parent of your vacation time. And there are different ways that two parents can arrive at a parenting plan. In a perfect world, they agree themselves. You know, they know their children better than anyone else, and they reach agreement on it. They can also use their lawyers. Chris and I help our clients all the time to determine what a good parenting plan would be, and we engage in negotiation, maybe through writing, maybe a settlement conference. A third option would be the use of a mediator, a neutral third party that helps bring the parties together to reach an agreement. And if all of those are unsuccessful, that's when we go to trial and a judge decides. Or in Lori's case, we had the judge decide, it was appealed, and the Nebraska Court of Appeals had to review it again. So she had a very long journey, and that's sort of the extreme of the possible scenarios.
Well, and admittedly, you referenced in a perfect world, and I would imagine that when a divorce is actually happening, you don't get a whole lot of agreement between the mom and the dad. So when you actually sit down to put together something like a parenting plan, we're not under the best of circumstances there. So I can appreciate that it sounds like we're moving in a direction where there might be more of a 50-50 split, but looking at this realistically, talk to us, Chris, a little bit about, you know, when we're sitting at the table there and we're trying to put together something that would be in the child's best interest, emotions have to come into play there, and decisions are made based on that. So the question's twofold. When you sit down to do that and you're not really in a place emotionally where you're set up to do it and do it well, what other steps can you take down the road to ensure that those parents are having equal time and that that what is being done is really in the child's best interest?
Well, I think one of the ways that you protect yourself and also your children is you secure effective representation, such as Susan or myself or some other attorney who does family law matters because they like to do family law matters. A lot of attorneys do family law because it's kind of expected, but they don't really like it. Susan and I have made a career out of doing family law cases because we like to help people who are in need of help. And in these situations where you're trying to put together a parenting plan and now the courts are referring parties to mediation, and you're absolutely correct, they're right in the midst of some of the most trying times of their lives, and mediation works well if both parties are on equal footing or on equal ground. It does not work real well when dad maybe is still in love with mom and is hopeful that mom will come back to him if he just kind of agrees with some of the things that she's saying that she wants, and And so then you can get a very jilted, tilted arrangement that isn't in the best interest of anyone. And the way you protect yourself from that is you have an attorney go with you to the mediation who knows what the default plan is if you can't come to an agreement and you're going to go to court. What does this judge normally award? If you have that kind of knowledge, then you can advise your client, well, you know, what she's asking, what he's asking is so far out of bounds, no court would order that if you guys can't come to an agreement. And so if you equalize the playing fields and powers, that's how you protect yourself. You know, you have to have the knowledge to do it right.
Well, and let's say there's somebody out there who's watching who says, gosh, Chris, that sounds like great advice, and I really wish I had done that. But now I'm in a circumstance that I don't believe is in the best interest of my child. The parenting plan has gone through, the decisions have been made, and we are months, perhaps even a year or two out, and this individual or individuals want to go back. There's one that's not in favor of it because life is just fine with them, and the other is not. What types of steps do they take that far out of the situation to try to go back and do it the way that they thought that it should have been done the first time?
There's hurdles that they have to get over. Once an order has been issued by a court, a final order, your divorce decree, in order to get a ticket to get back into court, to have a judge reconsider that matter, you have to have something big that has happened since the last court order, not before, but since the last court order, that changes everything. It's, you know, what they call it a material change. That's something big, something not contemplated by the parties last time they were in court.
What are some examples of something big, Chris?
Somebody decides they have a job in that they want to take in San Francisco. That's pretty big. When you have parents who are living in Omaha or Hastings, you know, Hastings is a pretty small town, probably in the same neighborhood. Now someone has a job in San Francisco, they need to change, the parenting plan will no longer work. So adjustments have to be made. And if adjustments have to be made because of where the parties are now, then the court can re-review it if it's put before the court. So you'd file your application to modify, because you're wanting to modify the first order. And you go through the process again to get an agreement if you can. And if you can't get to an agreement, then you throw it in the lap of somebody else who's going to make your agreement for you.
Okay, and Susan, a follow-up to that, what happens then if you're in that boat and something big doesn't occur and you're just increasingly frustrated because you think you've been beaten by the system and you want to have something done, but we don't have any of the circumstances that Chris just described? What type of action can a parent take at that point?
You know, I think that there are times when it's necessary for us to realize that the legal system and our lawyers don't have all the answers for us when it comes to our children. And what I like to do is to ask my clients, what is it that you most want? Is it more time with your children, more communication with them, an improved relationship? And if you can't get that through your parenting plan, how else could you get it? Could it be by volunteering at their school? Could it be by emailing them every day? Could it be by some other form of communication? Can you negotiate directly with the parent, if the other parent, if they're willing? Can you change your own job schedule to have more time with your child? To exercise what we call the right of first refusal. If you have that provision, which says that if the other parent can't take care of the child, rather than have the child be in daycare, I get to have my child. So you have to sometimes be creative, be persistent, and keep the focus on how can I get what I really want with my relationship with my child if the court isn't going to be of assistance.
Yeah, and again, I would think that that would be frustrating for that parent thinking, I'm their mom or I'm their dad, and all I want is time, and now I have to somehow, because of a decision that's been made by people that I don't typically know, I have to somehow creatively come up with ways to spend time. And so, you know, I guess what I'd like to do is maybe go to Eric and Lori with this question. If you were in that boat, and it really does sound like the two of you had pretty good circumstances, or as good as they could be under the circumstances. You know, Eric, if someone said to you, you know, I'm sorry you're not able to spend enough time, you're going to have to get creative, how is that going to make you feel as a dad?
Well, that's kind of where we sit right now, is that, I mean, I'm in the temporary orders, I've gone from being able to see all three of my kids on a daily basis, and now I've, you know, in essence been ordered that I can't see them except every other weekend and on every Wednesday nights. except through the summer. But yeah, that's the toughest part to get through that, is to be able to, on a daily basis, and now somebody else is telling you, now, sorry, you can't see your kids on a daily basis. So I guess that's where, you hope you can get through some of the mediation and talk, but yeah, it really doesn't work all that well. It just depends on the parties, is what it really amounts to. But it's where you are right now in your own circumstances is what it really dictates, is what's going to happen. So how well can you get along? How can you communicate? It's just like, emails, phone calls at night, stuff like that. So yeah, to be creative, I mean, that's what I do. Try to, call the kids each night. So you try to do anything, I guess you can, to be able to stay in contact with them and keep up with them.
And what's your advice to dads out there who may just be starting this journey and somewhat fearful that they could wind up where you're sitting right now? What's your advice to them?
Well, just what I'm doing there. Just try to keep in contact with them on that daily basis. As far as, I guess you hope the other party is willing and lets that happen, even if they have the custody. But I guess that's the main thing. Try to keep in contact with them so they know you're there. It's not their fault. They're caught in the middle of it. That's the biggest thing. So.
Okay, thank you. Lori, do you have anything that you would want to add to
I would
that?
just say cooperation isn't always forthcoming from the other party in a lot of situations, and that does make it difficult. But just to stress, the focus is on the child, and sometimes it's come down to almost a battle of hours, where if there's a family function that my son wants to go to, and it happens to be my ex-husband's week, we shouldn't be bartering 4 hours here, 4 hours there. And so what I have done is just kind of, if it's my time that he wants my son for something, it's like, just give him the time. It's not, if he says I'll trade with you on a weekend, that's not necessary. It's the time not taken away from me, but it's time given to some activity that my son will benefit from. So if people can think of that. And there is a parenting class that I think everyone now is required to go to in the state of Nebraska, and I think that is very helpful.
Now, Lori is mentioning a change in the law that we've had in place in Douglas County for a long time. It answers your question of when parents aren't at their finest going through a divorce, what helps them to make better decisions for their children? And that is an educational course that helps them look at divorce through the eyes of their children and helps them to see the benefits for their children in having this kind of flexibility and generosity of spirit and focus on the best interests of the child that Lori demonstrated, I think, throughout her process, and that really benefits children in the end.
And that's extremely admirable, and unfortunately that doesn't happen in a lot of cases, that people get so much into themselves that they lose sight of what's really important
Putting the
there.
child
and in the long
in the middle.
run, everybody hurts, especially the kids. I did want to ask a follow-up question. Chris, I'll gear this towards you first here. The courts make these decisions that impact, obviously, a lot of people. What is done, if anything, in the way of follow-up to families once those decisions have been made and you have some people grumbling out of the courtroom who don't think that decision is fair? And how can you decide that in just an hour? And here I've spent my whole life, raising my family and all of that, and now in so much time you've determined it. Is there anything that the system does to follow up with the families whose lives they've really impacted?
Short answer would be no.
Okay, nothing.
There's nothing. There's no review hearings of any kind that would occur like you would have in juvenile court to make sure things are progressing for the juvenile's sake the way you would want them to. You have that in juvenile court. You don't have that in district court, where divorces are typically handled. You're on your own. The judge hears the case. He makes or she makes the best call they think they know how, governed by whatever personal bents they may or may not have at the time, or maybe even how they feel that particular day when they climb out of bed. And that's the decision you live with.
And that's pretty difficult, I would imagine, to really try to process as a parent, to think that this system is set up in such a way that decisions can be made subjectively by individuals that don't know your circumstance at all. Lori, do you want to talk about that with your particular?
Yes, one thing I was pleased with, and that this would work for older children, not so much for younger children, but the judge hearing my case did actually speak with my son and got his input on what he felt would be a good arrangement for custody. And I thought, and that, like I said, that wouldn't work for every child depending on their maturity, but I was pleased that they did consider his input in the ultimate award of custody.
Okay. And Eric, how are you feeling about the process so far?
Well, just kind of somewhat the same there, but then just the same kind of process there. The lawyer for the plaintiff there is basically saying, I don't have a prayer. So how do you, he's saying that, but then, we're trying to work out some sort of custody, some side of a shared plan anyway. So how do you, it doesn't make you feel real well, not at all, especially when you got the outside influences, lawyers and judges, and it's out of your control in essence. So you don't have much input into the situation there. It's what's presented to them, and it happens to be that day or whatever the case is. So it's not good.
Chris, you mentioned earlier some of the big circumstances that would bring folks back to court, and one of the things that you said that caught my attention was if the sole custody individual moved out of the state, which I would imagine in an already not so great circumstance would be very upsetting to the parent who's left somewhat behind there. What do you generally, and I'll get to you, Susan, in a minute, what do you generally see in the way of outcomes for that kind of scenario?
It depends. How's that for an answer? There are a number of factors that our Supreme Court has told our lower courts. We have a 3-court tier in Nebraska. You have your district court, your court of appeals, and your Supreme Court. Our Supreme Court has laid down some factors that the district courts, that's your trial level, are supposed to consider when they're weighing these decisions as to do we let the custodial parent go with the kids or not. And one of those factors that is creeping up the list in terms of importance is how is this going to affect the non-custodial parent's relationship with the child. And so it's becoming, as that rises up the list of priorities, it's becoming more and more difficult for parents to say, I'm going to move to San Francisco. And it's the same burden if you're moving to San Francisco or if you're moving to Wichita. You cross the line, you're going to have this case to decide if you can go or not. It's almost what I would refer to as a free shot. You have to have this big ticket item to get you into court, this material change. If someone's going to move, and nothing else is changing, that's enough that you can actually relitigate the issue of who's going to have custody, because one of the factors that the court is to consider is it still in the best interest of the child that that parent maintain custody. So but it depends. I mean, if the parent who wants to move, their job is taking them there, say they're in the military, and they've been stationed somewhere else, well, more than likely the court's going to let them go so they don't get put in jail. But it's all over the board, and the judges are their own persons that make their own decisions, and so you can have one judge on one set of facts do one thing, and you can have another judge do something completely different on very similar facts.
Okay. And Susan, I know another indicator might be the child's age. We get to a certain age and children then are given a little bit more freedom as to where he or she wants to spend their time. Is there a magic age in Nebraska, and how do they really decide all that?
In Nebraska, there's not an age at which a child gets to decide. In fact, a child never decides, but their preference can be considered if it's based upon sound reasoning. So the older the child, the greater the weight a judge is likely to give to their opinion. And as in Lori's case, the court can consider whether or not to hear what the child has to say.
And at what age is that? If parents are watching this and they're saying, gosh, they're 11, they're 12, they're 13, what is that? And in a very limited amount of time left, what happens with the younger siblings then?
I don't think it's before that early adolescence, and then I think you look to the maturity and personality of the child. and what might be influencing them, because I'll tell you, a new car can influence a 16-year-old, or being able to play their video games whenever they want, or having no curfew. But it's very rare for judges to ever do split custody, in other words, where they separate children. So siblings are almost always kept together, and so the preference of one child is, again, just going to be one factor. And an older child, a court might be more likely to do a 50-50 arrangement, but it's not presumed that 50-50 is best for all children, because you might have a nursing infant, for example, who would not fare well with a 50-50 arrangement. So the focus should always be what is in the best interest of this child and this child's needs, and what is the capacity of each of the parents to meet this child's needs. So I think we don't start with any presumption, but that it's looking at each child and saying, what does this child need?
But are you suggesting that most oftentimes they do look at the group of kids collectively?
Yes.
They say, so if you have a 16-year-old, but you also have a 3-year-old, then the chances are good that they're going to look at the big picture and say, we'll get to that when that 3-year-old is older and probably in more of a position. Is that kind of what you're...
Yeah, and the closer in age, the more likely that is. If you have a big split in age, the court might be more inclined to consider, if there's a big distance in age, the court may be more inclined to award split custody, but it's rare, I would say. Okay,
and in just the very small amount of time that we have remaining, Susan, you say we're moving more in a direction where you think that 50-50 split is coming a little bit more frequently now between the parents. What are those parents who don't have that option right now? What advice would you have for them?
I would say focus on building your relationship with your children, focus on building your relationship with that other parent, be creative, and live your best life too, because very often what can happen is the custody litigation can consume your life, and then you're not being the best parent for your children under those conditions either.
Okay, thank you all very much. We do have a graphic that we want to share with folks that has some information, some phone numbers that they can call. If we want to go ahead and put that up. The Child Support Hotline is there for folks. We also have the Parent Assistance Hotline. And then finally, a hotline for abuse and neglect. All right. Well, thank you all very, very much for joining us. Difficult topic. We appreciate you sharing your thoughts with us today. Thank you all for joining us. We'll see you next week.
Consider This is an issues and information program produced by UNO Television. More information and program archives can be found at untv.unomaha.edu. If you'd like to share your comments about this show, call UNO TV at 402-554-2516 during regular business hours. The 11th season of Consider This is brought to you in part by From the Top, a national program showcasing the musical talents of young people. From the Top can be heard on KVNO Classical 90.7 each Saturday at 6 p.m.